party's production of enough evidence to allow the fact finder to infer the public supports a charge of failure to pay taxes payable to KRA, to it the sum of Kenya shillings 38,692,694, being principal tax, penalties, and accrued interest. To prosecution. The charge herein deals with tax matters. According to the refund of tax, to this section 32(1) thereof is relevant. It states, tax as debt due to the state, section 32(1), a tax payable by a person under tax law shall be a debt due to the government and shall be payable to the commissioner. The term tax law is underlined, and that was my emphasis. According to PW1, taxes are paid according to the type of tax, and the law determines when tax is due. This debt was to be recovered by the recovery unit of KRA. This witness was aware that the taxpayer had been paying towards the tax assessment, which was communicated to the EACC. The due date, according to the TPA, means the date by which taxes are due and payable as specified in the respective laws, or such other date as the commissioner may specify in a notice. The same act defines tax as a task or penalty imposed under tax law, or installment value added tax and excise duty act. The charge sheet did not specify the amount of tax due under each of the various tax law regimes mentioned above with specificity and their due dates and the amounts involved, in order to call for evidence to prove those specifics as required in law. Section 137J of the Criminal Procedure Act gives guidelines when, while drawing charges of a gross sum, may be specified in certain cases of stealing under Section 280, 281, 282, 283 of the Penal Code. If the court was to take cue from Section 137J, then it was expected that in order to charge a gross sum, as done in this case, that could only be done if there was a common thread, i.e. gross sum under one regime of the tax law applicable. This is also required in order to satisfy Section 52B, Article 52B of the Constitution, which requires that every accused person has a right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer it. From the above observation and according to the law, several violations of tax law were lumped up in the same charge. Under Section 45(1)(d), of which the accused were charged, and to be specific, the ingredients are as follows: fails to pay tax or any fees or charges payable to any particular body or effects, or obtained any exemption, remission, reduction, or abatement from payment of any such taxes, fees, levies, or charges. The charges should have been framed with specificity as to the amount of taxes not paid. It should also have specified the penalties not paid in the charge sheet, and also with specificity. The amount of interest accrued in each regime in the charge. It's a cardinal rule of law that criminal acts are charged singularly and independently. And to amplify the above, Section 95 of the TPA provides that a person fails to pay tax by the due date. This provision, as read with Section 45(2)(d) of ASECA, and what is construed by the court is that the due date ought to be included in the charge sheet for the specificity in order to demonstrate when the offenses were completed according to the regimes they fell. Tax matters are matters of records and figures. Investigation and prosecution of such cases should be done with precision. PW5 informed the court that they relied on the assessment from KRA. They did not demonstrate their own independent investigation, decisions, and findings, considering the fact that TPA contains guidelines to the Commissioner on how to deal with an assessment and collection of tax and is not delegated to any party. PW5 informed the court that he lacked sufficient knowledge on matters dealing with tax. In the High Court petition number 22 of 2018, Michael Sistu Mwaura Kamau versus EACC and 3 others, one of the issues to be decided was one of a defective charge sheet. The petitioner had claimed that the charges as framed were an omnibus and unconstitutional, vague and ambiguous, in that the breach of Financial Regulations Chapter 5 were too wide, and one needed to know which regulation among Chapter 5 was violated. The judge found the charge in respect of count 1 ambiguous. Article 52 B of the Constitution. The judge went ahead to remove the charge to the High Court and quash the same. The judge, however, gave the prosecution leave to amend the charge if they so wished. In the case before court, the prosecution already closed its case, meaning that the opportunity is not available. Consequently, and in the same vein as held in the case above, the charge herein as framed lacks specificity as to the actual tax law that was offended, the actual figures involved in relation to each tax law, and the time when the tax law was offended, thereby making the charge herein fatally defective. For this reason, and alongside other observations made by the court herein above, the Republic failed to establish a prima facie case against all accused, and they are acquitted under Section 210 of the CPC Cap 75 laws of Kenya. They shall be released forthwith unless otherwise lawfully held. It's so ordered. Yes?
I wanted to make an application that the cash payments, because the accused person is released in some direction, so when the fair copy is available in court, we have to get a copy of our payment.
You are talking about cash bail.
We have no objection to the refund.
Yeah? Copy
We
of
have
the...
no objection to the refund sought by the depositors.
I'll make some corrections in the ruling.
Much of that, I was listening.
Call out, call out.
Dr. Evans Okinko Kidero. Manasseh Karanja.
Start with accused 3, continue with accused 3.
John Giral.
Yes, you see, did not conduct their, such kind of.
Okay, we are very. It has been a long journey with this case, starting in 2016. The investigator has been after the client, with the investigation. The investigator is obviously the EACC. They've been investigating the client for all sorts of offences, and when they've lost several in the High Court, they decided to charge them with a tax offence, which is the mandate of the KRA. So our argument has always been that the charges that they were alleging against the client was something that was settled by the KRA through valid assessments, which is the procedure under the Tax Procedures Act. Today the client has been vindicated, even though the court found that the charge sheet was fatally defective. The other findings were made that the investigator was not even a competent person to investigate tax offences.